Hello, I'm Jeff Marks, the attorney for the Northeast Florida Association of REALTORS. I have been asked to explain the main differences between the NEFAR form of purchase and sale agreement and a Zillow form on properties owned by Zillow Home Properties Trust. Apparently, Zillow will only accept offers on their own form. They're allowed to do that. They're the seller and they can set that rule. You will have to submit the offer through their portal. When you go into the MLS under a certain property address, the form of contract and their instructions will appear. It's different than the NEFAR contract and from the FAR bar contract, but I think it's well drawn with a couple of exceptions that I think are vague, and we'll go page by page on the differences. One of the main differences is style. You'll notice that the price is not on page 1, but rather on page 2. We're used to seeing it on page 1. I would recommend that you read the entire contract before you go over it with the buyer. My presentation will help you understand it, but please read the entire contract. So the first paragraph is the buyer's name. One of the things it doesn't state is show the marital status. You and I know that it's important that you show it because the Florida Constitution says a buyer can't put a mortgage on the property without their spouse joining. So if they're married or unmarried, you should state that. It also says that the closing will be at a certain title agency, and they give you a contact for that. But it goes on to say buyer's not required to use that closing agent that is suggested by seller, and you can change that by going in their paragraph 9.18, which is additional terms and conditions. So apparently you can change that. Another difference on page 1 is it doesn't have a legal description, and that's probably okay. It's got a place for the street address and for the property assessor's parcel number. And so in 99.9% of the cases, that would be enough to make a valid contract. The law of Florida is that if a surveyor licensed in the state can identify the exact property from the address and the parcel number, then that would be sufficient. We're used to seeing a legal description, but it doesn't absolutely have to have it. Another major difference follows. Most contracts I've ever seen list the items of personal property that are going to convey at the closing. This one does not. Let me read you what it says. It says you get the property and all structures and other improvements on the real property owned by seller, together with all lighting fixtures, all electrical, mechanical, plumbing, air conditioning, and any other systems or fixtures that are attached thereto, collectively known as the improvements, and all rights and easements appurtenant to the property. So whereas we're used to seeing range, refrigerator, dishwasher, etc., this doesn't have it, but it would seem to include everything that's there if the seller owns it. It does say, except that what's not included is an electronic deadbolt lock, if applicable, and any smart home equipment attached to the property for purposes of showing the property. That is a cellular hub or motion sensors. Those things don't convey. It says, notwithstanding that, seller will convey specifically identified smart home equipment, and then it gives you a place to put it. That's similar to ours. We say smart home devices, please specify. But it goes on to say this, and presently the NEFAR contract does not have this language. It says, any smart home equipment conveyed to buyer does not include the corresponding operational service contract. Buyer shall be fully responsible for entering the service contract with a third party. So that is a difference. That concludes page 1. On page 2 at the top, it's got a place for the purchase price, and then underneath it has boxes for a cash, conventional loan, FHA, VA, or other. Other might be USDA. There's also a contingency addendum that you should use because it has the specific VA and FHA requirements in more detail. Another slight difference is in the effective date. The NEFAR contract says it's effective on the date that parties have signed and each party or their agent has a copy. This one just says it's on the last date that it's been signed by the buyer and seller. When it comes to closing, it's similar to ours. It says on or before and a certain date, so that much is not different. And it goes on to say that if that closing date falls on a day that's not a business day, it would go to the next business day, and that is similar to ours with just slightly different language. With regard to the binder deposit, it talks about how much the deposit in is, but it says it's due within 3 days after the effective date. So there's no chance to fill in any different date. So apparently it's just due within 3 days. And it says obviously it has to be by wire or other form acceptable to the closing agent. So if the closing agent allows a check, as our firm would, that would be satisfactory. For additional financing terms, it says see this Schedule 1 that we'll come to toward the end of the presentation. Now there's something at the bottom of this page that I think needs clarification, and I've tried to get it, but I can't get it yet from Zillow. It says the following additional financial terms will supersede any inconsistencies in the Schedule 1 of the state addendum. So there's a dot that says buyer closing costs blank dollars. What does that mean? I don't know. I don't know what it means. Underneath it, it says HOA fees blank dollars. I guess that would be annually, I'm not sure. Underneath that, it says home warranty, and that concludes page 2. At the top of page 3, it says home warranty, and would that be filled in only if the buyer is paying the home warranty? And then it says other costs, and then a line for seller concessions. So that's the weakest part of this contract, in my opinion. It goes on to say that in the event the contract is properly terminated in accordance with these terms, then the deposit would be delivered to the party who is entitled to that. And then it says neither buyer nor seller will reimburse any party for any expense. So unlike the NEFAR contract that says if the buyer terminates, like because they didn't get the financing or during the inspection period, the buyer would have to reimburse the seller for the survey map and title search, for example. Or if the seller terminates in the unlikely event because they can't deliver clear title, they would have to reimburse the buyer for the appraisal, credit report, and inspections. This one says no, nobody reimburses anybody in that instance. There are contingencies to check box at the bottom of page 3 for a financing contingency, appraisal contingency, sale of other property contingency, and then those are covered in more detail on an addendum. There's one part that bothers me a little bit at the page 4 that we're now on. It says the buyer is going to accept title with any exception set forth in seller's deed, and I'm really not sure what that means, but later it talks about title having to be marketable. So my best guess is that would protect the buyer from anything weird that would be in seller's deed. The inspection says, similar to ours, the buyer has 10 days if left blank, but it ends at 5 p.m. You know, the NEFAR contract ends at 9 o'clock p.m. Eastern time for everything except the actual date of acceptance. If the offer says the seller must accept by a Saturday or Sunday, a legal holiday, we mean that. But for every other time period in their inspections and financing and closing, we go to that 9 o'clock Eastern. It goes on to say, like ours, that the seller will provide reasonable access to the property. It doesn't say that they have to have the utilities on, but I would think that is implied by law. It has a hold harmless like ours, that if somebody's hurt, the buyer can't blame the seller for that. And it says, it's somewhat like ours, that buyer is solely responsible to verify and confirm during the inspection the accuracy of any statements provided in the listing information. Now ours is different in that regard though. We're on page 5. Ours says that the buyer has not relied on any other information, including the listing information. Theirs says that buyer is responsible to verify any statements, including in the listing information. So that is a difference. It says that seller would deliver copies of reports that they may have, but they don't warrant the accuracy of them. So if they had an old WDO or a home inspection report, it goes on to say that buyer will acquire the property as is with all faults. Ours is very similar to that, but as is with all faults. But on page 6, there's a big difference. In paragraph 3.7, this is written. Proof of funds within 3 business days of being requested by seller, buyer agrees to provide written evidence from a bona fide financial institution of sufficient cash available to complete the purchase. It's not unreasonable, but it's different than what we're used to seeing. Section 4, also on page 6, talks about the marketable title. It uses an expression or two in this contract that we don't, they call it about close of escrow, and we just call it closing. But in paragraph 4.1, they say that you'll accept title subject to existing year's taxes, assessments, and they say reservations and patents. That's a very old-time legal expression that doesn't really apply around here. We don't have any patents. And then it says all other matters of record and encumbrances, and so that bothers me, though I think the marketable title part would take care of that. It does say here that buyer is responsible to pay for costs to procure extended or other additional coverage on the owner's title insurance. So here, like ours, it says the seller, in this case Zillow, will pay for the owner's title insurance and the buyer would pay the simultaneous mortgage and endorsements. But this says if there's additional coverage for that the buyer wants, let's say that there's a survey map that shows a slight encroachment and the title insurance company is willing to title insure that, that's done by an endorsement known as the 9.2. In our contract, the seller would pay that. In this contract, the buyer would. And it's several $100s, depends on the selling price. But that is a difference. At the bottom of page 6, there's a big difference, maybe a $300 difference. It says the buyer is going to pay the cost to procure a new survey. If the buyer wants a new survey map in this contract, the buyer pays for it. In the NEFAR contract, it's marked for either party, but customarily the seller pays it. Now we're on page 7. It goes on to say that the seller is going to execute the deed and any documents the closing agent requires and deliver the keys, and the buyer will sign the documents reasonably necessary to complete the document. Now here's something different. It says as to the buyer, in order to ensure that closing occurs on the closing date, the buyer will use their best efforts, whatever that is, to ensure any loan documents are delivered to the closing agent at least 2 business days prior to closing. Good luck. As you all know, we're lucky to get the closing documents from the lender a few hours before the closing, but this one says the buyer would use their best efforts to ensure that the loan documents get to the closing agent 2 days before. I guess all the buyer can do is ask their loan officer to please do that. We're now on page 8. The top of page 8 has a fairly normal proration paragraph, except one thing is not there. It says that the taxes and association fees and solid waste fees are to be prorated. It does not mention rent. So in the rare instance where the buyer's inheriting a tenant, we would prorate the rent. I suppose that's not likely to occur with the Zillow-owned property. There's not likely to be a tenant there, and that's probably why they don't have it. But one other difference is that it says that there will not be a reproration. It says to use the best information available. So right now, if we did a closing, we would not know what the property taxes are for this year. We would have to use the best information available. We know that if Zillow acquired the property prior to January 1 of 2021, that it would not be homestead exempt this year, so the property will come off the tax cap and will be assessed at about 92% of its fair market value. We who do closings would contact the property appraiser to get a best estimate of what those taxes are, and we prorate. The NEFAR contract said that the one who was shortchanged could require the other to reprorate. This one says opposite, it says there will not be a reproration, so be careful with that difference. It says possession will be delivered at closing. As you know, the NEFAR's got some options where the seller could remain in for a couple of days. Obviously, Zillow does not need to be remaining in possession. They're not occupying the property. The default paragraph is similar in that it says if the buyer defaults, the deposit would be forfeited to Zillow as the seller has liquidated damages. That's it. But what is a little bit different is that if there's a breach by seller. So it says if seller breaches its obligations under this agreement without cause, buyer's sole remedy is to terminate the agreement and get a return of their deposit, and buyer waives the right to seek specific performance or damages. That's not good. That means that Zillow could simply change their mind. Maybe they saw a higher offer come in later and they could kick this buyer out and all the buyer can do is get their money back. So there's a risk there. Be aware of that. That is in section 6 on page 8. That is probably the scariest thing in this contract, in my opinion, for your buyer. We're now on page 9. They say that seller Zillow has never occupied the property, and so to the extent allowed by law, a buyer waives the right to get a seller's property disclosure. You know, there's no Florida law that requires a seller to fill out a property disclosure. NEFAR gives you that form, and we like it. But the law that we're bound by is the case of Johnson versus Davis. In the mid-1980s, the Florida Supreme Court ruled that sellers of residential property have an obligation to disclose to buyers material adverse defects that adversely affect the value of the property. So we'll call them latent defects. And so they're saying because we haven't occupied it to the extent allowed by law, that would be waived. I would say that in all likelihood, if the buyer could prove that Zillow knew of a defect, they have a good chance to win a suit. But buyer needs to rely heavily on their own inspections. They have a place for a lead-based paint disclosure. They have a very similar paragraph to ours about mold, a very short paragraph. They have the required paragraph about radon. Now, as to real estate commissions, here's what it says on page 10. Listen carefully. Buyer hereby acknowledges that seller has disclosed that certain affiliates of seller, for example, Zillow Inc. and Zillow Homes Inc., and employees of seller, including Zillow Home Advisors, market sale managers, and transaction managers, are real estate licensees in the jurisdiction where the property is located. Certain employees who have a real estate license under Zillow Homes are authorized to sign the contract documents on behalf of seller. Buyer acknowledges that neither seller nor its affiliates or employees represent the buyer. So we'll come to the commission part. I made a mistake in saying it was there. It's just a disclosure there to buyers that none of the Zillow agents represent the buyers, and that ought to be something buyers already know. There's a paragraph similar to ours that says this document contains and any addenda contain the entire agreement between the properties. As we all know, nothing verbal counts in real estate. There's a difference here that says, except if grossly negligent, the closing agent is excused from any insolvency involving the deposit. So if a title company or lawyer is holding the deposit and for some really unusual reason that bank went belly up, it says you can't blame the settlement agent for that. I don't see any great harm in that, though it's different than ours. Now for the brokerage part. This is paragraph 9.5, paragraph 11, the part you'll want to listen to. It says, except for, and they say the DJ and Lindsay team, seller's broker, apparently that's who has the listings here, the DJ and Lindsay team. That is acting on behalf of seller, except for that, and blank, buyer's broker. So there you would fill in the name of your company, acting on behalf of buyer. Each of buyer and seller represent and warrant to the other that it's not retained any other agent. So we've got something similar in there and in the listing agreement, but this is okay, but it's got a place for you to fill in the name of your company. It says that each party would indemnify the other if that's not a true statement. It says, unless otherwise agreed to in a separate document executed by seller's broker will not share any commission nor be responsible for paying any other party's commission. So this is something you need to make sure that Zillow has offered something in the MLS. It wouldn't be in the MLS if they didn't. And that's what you need to print off and have that date sensitive so you know what they've offered. Similar to ours, there's a paragraph that says in the event of any litigation or any other dispute resolution, neither party can have attorney's fees from the other. That's similar to what the NEFAR contract has. It's different than FAR-BAR that says the prevailing party is entitled to costs and attorney's fees. But like NEFAR, this one says each party would pay their own attorney's fees. 9.9 paragraph is a little different. It says that the buyer cannot assign this contract without the seller's prior written consent. Our contract says right on like line 3, the buyer, or they're assigned. So the NEFAR contract is an assignable contract unless the buyer is going to get the seller to hold the mortgage, then that finance addendum says it's not assignable. But the NEFAR contract is an assignable contract. This one is not. 99% of our buyers don't want to assign their contract. This would be a problem for an investor buyer who wanted to flip the contract. They could not do it with this Zillow contract. Page 12 is similar to ours. It says it can be signed by email or e-signature, and it says or by fax. We took out the fax part in ours, but it can be signed electronically, and in fact, it's going to be entered in their portal. This is an interesting paragraph that is not in ours. It says, sellers never occupied the property and therefore may not possess all garage door openers or other methods of access. Buyers on notice to obtain a new garage door opener or new garage door opener remotes and secure such other points of access upon taking possession. I think most of you advise your buyers to rekey the locks, but this says they're wanting the buyer, they ought to get new garage door opener remotes. It's advice from the seller. Ours is a little different on paragraph 9.14. This says, as they use the time phrase, sometimes business day. A few times they use business day. We never use business day in our NEFAR contract. We count all calendar days. But this says the phrase business day means Monday through Friday, except recognized federal holidays or recognized state holidays. Now, there are some weird state holidays. And so I'll tell you a few, and this is a difference. Our contract, when we're counting time, only excludes the 10 common federal holidays, but this one says or state holidays. So I'll list you a few, but if you want to write this down, the Florida statute number for the list of state holidays is 683.01, Florida statute 683.01. So just to whet your appetite, here are some of the bizarre state holidays. The birthday of Robert E. Lee being January 19th as a holiday. The birthday of Susan B. Anthony being February 15th as a holiday. Good Friday is a holiday. Pascua, P-A-S-C-U-A, Florida Day, April 2nd is a holiday. Confederate Memorial Day being April 26th is a holiday. The birthday of Jefferson Davis, June 3rd, is a holiday. So there may be an extra day in there for either party to perform. You'd have to check that statute if that ever comes up. They do have a wire fraud warning. I'm glad that they do. I hope all of you are putting in your email template a wire fraud warning similar to what we have in the NEFAR contract. This would give you some protection if you're accused by the buyer or seller of contributing to a wire fraud, but because now if it's in your email template, your defense would be, hey, every time I email them, I warn them that they need to call the intended recipient of the wire and make sure the wire instructions are correct. Here's something different. I don't think it's difficult, but it says buyer agrees to participate in up to 3 customer surveys. That's not a survey map, that means questionnaires, from seller during a 1-year period following closing. Never seen that before, but there it is. There's a paragraph for additional terms where you could write some things in. I don't know if they would accept that. Now I'm on a document called Exhibit A. It's a contingency addendum, and you need to use this in every case, in my opinion, unless it's a cash purchase, but you still may want to use it. The first part says financing contingency. There's a box. This agreement is not contingent on buyer obtaining financing, so there you would use it even for cash. Or B, most commonly, you would mark that box, buyer's obligation to purchase the property is contingent on buyer obtaining financing in accordance with the following provisions. And then there's a box for VA, FHA, conventional, other. The other would be USDA, in my opinion. Now listen to what it says right under that. Within blank business days, 3 if left blank, of the effective date, buyers shall submit a completed loan application to lender. The NEFAR contract says blank, 5 if left blank. This is 3 business days, which may or may not be different depending on what day of the week you're signing this. And then it says, this is different, if requested by seller, being Zillow, furnish a pre-approval letter to seller based on standard factual credit report and review of debt to income ratios. So if seller requests, then the buyer has to submit a pre-approval letter, a real pre-approval letter. It goes on to say if buyer fails to complete any of these conditions within the time period, seller has the right to terminate the contract and the binder would go back to the buyer. So be aware of that. Now, when do they apply for the loan? This one is quite a bit different. It says within blank days, 14 if not filled in. Well, ours says 30. It used to say 45. I'm not sure a buyer can get a loan approval within 14 days. So I think you'll need to fill in 30 there on almost every case. That's quite a bit different. There's a place on the next page for an appraisal contingency. It says the agreement is not contingent on appraisal, which could be for a cash buyer, or the box that buyer's obligation to purchase is contingent on the property appraising for not less than the purchase price within blank days, 21 if not filled in, of the effective date. And that's not business days. See how they go between days and business days? I don't care for that. Buyer agrees to obtain an appraisal of the property, and if buyer gets written note from the lender or the appraiser that it didn't appraise for the price, then buyer can either waive it or cancel and get their money back. So it's done fairly, in my opinion. Then there's a contingency if the buyer needs to sell a property. One of the boxes says it's contingent on the buyer entering into a contract to sell their property. So they've not even got a buyer yet. But if you look at the instructions that go with the property, at least the one that I pulled, says they will not accept that offer. So you'll have to read the instructions. But they might accept an offer where it says it's contingent on buyer closing on one that's already under contract. And on the instructions that I saw for this particular house that I downloaded, it said that the buyer's contract to sell their home, it has to be at a time past, P-A-S-T, past the inspection period of the buyer's home. And then they might well go along with it. And then it says seller can keep the property on the market during the sales contingency period until seller receives notice that buyer satisfied the requirements. So obviously sellers can always continue to market the property, and we have a continued marketing addendum that's somewhat similar, but this says that they can keep it, actively on the market until that's taken care of. On page 3 of the addendum here, there's a part that says the form of deed, and there's a difference here. It says the deed would be a special warranty deed. So let's examine that. Ours says it'll be a general warranty deed, or a trustee's deed, or a guardian's deed, as appropriate to the status of seller. So unless it's owned by a trust, then in 99% of the cases under the NEFAR contract, the seller will sign a warranty deed. Is it safe to advise your buyer that it's okay to accept a special warranty deed? The answer is probably yes, because we really don't rely on the warranties in the deed, we rely on the title insurance. So as long as there's title insurance, it's okay, and the title companies will insure a special warranty deed. What's the difference? In a general warranty deed, in the fine print it says the seller warrants to the buyer that the seller owns it, that it's free and clear, that the seller has the right to sell it, and the seller will defend the buyer's title in court if necessary. In a special warranty deed, the seller says, we only guarantee that we didn't mess up the title. Anything before we got it, we don't guarantee. So while it's better for a buyer to have a general warranty deed, it would be okay, in my opinion, to accept a special warranty deed. You'll notice that some builders do that and reload companies as well. The next part of the addendum discloses permits. In the NEFAR contract, the seller is representing that they didn't make any improvements without a permit if a permit was required, except, and there's a place to disclose, and then it says seller needs to close those out. This one is different. Remember, Zillow didn't occupy the property. So they're saying seller, Zillow, does not know of any improvements made to the property which were made without required permits or made pursuant to permits which have not been properly closed. So they're not aware of any of it, but that they don't guarantee anything there. So it's important that you look at a municipal lien search during the inspection period. In this form, we'll come to it. It says a seller is going to provide a municipal lien search, but I don't know if you can get it timely. The buyer may want to spend their own money, probably under $100, and get a very quick municipal lien search if you can. The municipal lien searches are taking longer than they ever have, so it may be something you should order yourself right away. The flood zone part is a little different. Let me read it to you. Buyer is advised to verify by elevation certificate which flood zone the property is in and whether flood insurance is required. That part's kind of similar, but it says here, if the property's in a special flood hazard zone or a coastal barrier resource zone, and if the lowest floor elevation of the building and or flood insurance rating purposes is below the flood elevation, or if the property is not eligible for flood insurance coverage through the National Flood Insurance Program or private flood insurance, then the buyer can terminate this, and they would be within 20 days after the effective date and be able to get their binder back. So they need to check the flood zone, soon. Under seller disclosure, they say seller doesn't know of any defects about the property that materially affect the value. That's the Johnson versus Davis. But they say, seller's not guaranteeing that. When it comes to survey map, addendum, there's a place to mark it, and you'll want to mark it because if you do, then the seller has to provide a copy of the survey if they have it. And if they have it, they'd have to sign the survey update affidavit so it could be title insured. But again, if they don't have one, or if it's not an accurate one, then the buyer's going to need to pay for their own survey. I'll repeat, in this contract, the buyer would pay for the survey map. It's got the built-in homeowners association community disclosure part, and they have that separately initial. It's got a coastal construction control line paragraph, which is only for oceanfront properties, and there's a place to waive it or request that the seller provide a survey that shows the line or affidavit. So my advice would be, unless it's an oceanfront condo, the buyer should not waive that. The buyer will want to know where that CCL is. So there are some older homes in our jurisdiction in the beach that violate the later imposed setback line. That is, they're built too close to the ocean from what the line would now require, but they're grandfathered in. But the concern is if they're destroyed in a fire, flood, or hurricane, or any type of destruction, they can't rebuild seaward of that line without a special exception from the state, and they may not be able to get that. So I would not waive that. You got to be real careful. They have a box about defective drywall. I don't think that's a big issue here like it was in Southwest Florida. In South Florida, it was a big issue with defective drywall. So that you can waive that part. I don't see any problem with that. Now there's an interesting Schedule 1, this is the last part of the contract that we'll discuss, that's supposed to kind of clarify who pays for what, but it's still not clear to me. So parts of it are, it says preparation and recording of the deed as a buyer expense. I'm guessing that means the buyer pays the settlement agent. As you know, it's customary here for the seller, but here it looks like the buyer's going to pay. And then it says the deed stamps will be paid by seller, that's customary. It says escrow fees and costs. Again, we don't use the word escrow fees, but I think they mean that the settlement agent's fees and costs. Each party shall be responsible for their own fees and costs. I really don't know what that means. It's not terminology that we use in our part of the country here. It goes on to say if there's charges required by the Owners Association for any capital contributions would be buyers. That's pretty standard. The owner's title policy is the sellers, and the lender's title policy is the buyers. And it says the municipal lien search is the sellers, but I'm concerned you may not get it timely enough. Now, finally, what's in the NEFAR contract that's not here? Other than what I've spoken about, I'm now going to tell you some things that we have in our contract that are not in this one. We've already said there's nothing about the buyer marital status. There's no legal description. It doesn't say utilities have to be active, but I think that's implied. It doesn't list in detail like ours what the buyer ought to inspect for. We've got 3 paragraphs in the buyer inspection. Ours is in paragraph 3. It says buyer you ought to inspect for. And this is really a bit of an eye-opening for the buyer and a little bit of a CYA for the sellers and the realtors, saying, buyer, these are all the things that you ought to inspect for and anything else. They don't offer those details. Importantly, there's no automatic extension built in if there's damage or destruction of the property by an act of God or hurricane, or if there's a change in financing by the CFPB. So, as you know, ours has it built in for automatic extension if the property is damaged or destroyed, and it has in there if the damage is 3% or less of the selling price, the seller has to fix it. And if it's over 3% and the seller agrees, the buyer can still say no. They don't have that in there. There's no detailed list of the personal property, no detailed list of who pays what closing costs. There's nothing in the Zillow contract about the PACE liens. That's property assessed clean energy. So in Clay County only of the NEFAR jurisdiction, is it possible that there be a PACE lien for energy improvements? There are about 100 houses in Clay County that have it. There's nothing in here that addresses that. There's nothing in the contract that says be careful if the property's in a historic district. We in there say you can see this certain explanation that we have. There's nothing in there that says buyers, you ought to check out neighborhood crime and sex offenders. And finally, there's nothing in there that says sellers are obligated to sweep the property clean. So you'll know when you go through there whether they ought to do that or not. And if it's just terrible, you could cancel during the inspection period. All right, so those are the differences, and I hope this has been helpful to you. Thank you.